All right, welcome back to Emergency Medical Responder Program. This is Chapter 4. We're going to discuss medical, legal, and ethical issues for the first responder. All right, so as an introduction, laws, they do differ from one location to another. So from state to state, county to county, they can differ as far as what a first responder is and what your responsibilities are. So the first responder, the emergency medical responders, should learn specific laws that apply in their state and local jurisdiction. Do not lose sight of these following concepts, though. Above all, we're going to do no harm. Above all else, we're going to do no harm for our patients. And we're going to provide all your good care in good faith. Okay? Provide proper and consistent care and be compassionate and maintain your composure with all patients. All right, duty to act. If you are employed by an agency as a first responder and you are dispatched to the scene of an accident or illness, you have a duty to act. Note what I just said, employed. So you are clocked in. You are clocked in as an employee. You're being paid to be a first responder. Then you must proceed quickly to the scene and provide emergency medical care with the limits of your training and available equipment. That being employed and being on the clock is your duty to act. Failure to respond or render necessary emergency medical care leaves you and your agency vulnerable to legal action. So as you can see here, all these first responders are there. They're on duty. They're working for what looks like to be the fire department, and they are at the scene of the emergency. They have a duty to act. The standard of care. The standard of care is the manner in which you must act or behave. You must meet two criteria. One, you must treat the patient to the best of your ability. Two, you must provide care that is reasonable, that a reasonable, prudent person with similar training would provide under similar circumstances. This is your standard of care. And the standard of care is what you're being taught right now, okay? It is the manner in which you're going to act and take care of patients. Scope of care. The scope of care is defined by the U.S. Department of Transportation's Emergency Medical Responder Educational Standards. These are found under NHTSA. Remember, we talked about that earlier. National Highway Transportation Safety Administration. The U.S. Department of Transportation has been melded into that organization. And then, of course, your scope of care is defined by your medical protocols, by your medical director, which also should include your standing orders. And then, of course, if you're speaking directly with the physician, online medical direction. Ethical responsibilities and competence, one of two. Treating a patient ethically means doing so in a manner that conforms to an accepted professional standards of conduct. You need to stay up to date on your skills and knowledge. That's a big one, number one. You also need to have reviews of your performance and assess your techniques, not only by yourself, but also of your supervisors and quality assurance officer. Everybody needs to evaluate their response times and see if there's any way that we can make sure that we get there quicker without jeopardizing public safety. Try to follow up on patient outcomes to see how well they did. Take continuing education classes, renew your CPR, renew your first aid, renew your EMR, every 2 years or whatever is appropriate for your state. And then participate in any quality improvement activities. You also need to understand ethical behavior requires honesty. Always provide complete and correct reports to other EMS providers. Never change a report except to correct an error. All right, consent. Very important. Consent simply means giving approval or permission. First one's express consent. This is exactly what it says. It's expressed. The patient actually tells you, verbally or non-verbally, otherwise shaking their head, that he or she is willing to accept your treatment, your help. A patient must be of legal age and able to make rational decisions to do so. Implied consent. This is the next one. The patient does not specifically refuse emergency care. They are unconscious, unresponsive, or for some reason are incapacitated to a point where they can't express to you their consent. So therefore it's implied. Then you have consent for minors. Under the law, minors are not considered capable of speaking for themselves unless they're emancipated. That's a whole different ballgame. We'll talk about that after a bit. But consent for the minors usually comes from the parents or law enforcement, or if it's an emergency, it will fall under implied consent. All right, so emergency medical treatment on minors must wait until the patient or legal guardian consents to the treatment. If permission cannot be obtained quickly, don't hesitate to give appropriate care. Because, again, if it's life-threatening or limb-threatening, we're going to manage that as an implied consent situation anyway with the minors. All right, patients or consents for patients with mental illness. If the person appears to be a threat to self or others, you need to place this person under medical care. So you can physically take them into a temporary custody until such time that they can put it in a more permanent fashion in order to help them. Now, you need to know your state's legal mechanisms for handling this type of patients. States do vary from one state to another on incapacitated patients. But don't hesitate to involve your number one working guy or gal out there as your law enforcement agency. An officer will be able to help you with these, period, and to help you manage somebody who has a mental illness. All right, patient refusal of care, one of two. A competent adult has the legal right to refuse treatment. You cannot force treatment on anyone. Help the person understand the consequences of refusing care by explaining the following: what the treatment is that you want to give to them, the reason that the treatment is needed. Let's get rid of me again. The potential risk if the treatment is not provided, and then any alternative treatments that may help them. All right, so patient refusal should be documented on your patient care record according to your agency protocol. So if they absolutely refuse, you're going to need to make sure that you document it and turn that documents over to the appropriate agencies when they arrive on scene. Because you're not going to be letting these patients loose. It's going to be the responsibility of whoever the secondary responders are going to be, such as the EMTs and paramedics. Advanced directives. Okay, an advanced directive is a document that specifies what a person would like to be done if he or she becomes unable to make their own medical decisions. The first one is a living will. This is a written document drawn up by a patient, a physician, and a lawyer. It states the types of medical care that the person wants to have or wants to have withheld. It is called a living will. It is an advanced directive that says, I want these things done for me in the event that I can't make those decisions. Durable power of attorney for healthcare and healthcare surrogates. It allows for a patient to designate another person to make those decisions about the medical care. And then finally, one that you may or may not have heard about before, the do not resuscitate order. This is a written request giving permission to medical personnel to withhold resuscitation in the event of cardiac arrest. Now, let me make clear of that. If their heart stops, then we don't do CPR. If their heart is still beating and they're not breathing, we're still going to help them. Okay, you still have to support or provide palliative care, support the respirations, and or provide palliative care to make them comfortable. Right, so if you're unable to determine if an advanced directive is legally valid, then you need to begin appropriate medical care. Some states have systems in place such as bracelets to identify patients with advanced directives. Some patients have tattoos. I mean, just all kinds of things. Just make sure that it's correct. And if you feel uncomfortable with it, you feel that it isn't valid, then do what you need to do to treat the patient appropriately until other responders get there. Abandonment. Abandonment occurs when a trained person begins emergency medical care, then leaves the patient before another trained person takes over. So if you start helping somebody, you cannot abandon them or stop helping those people or that patient until somebody of equal or higher care comes along and relieves you. So once you started that treatment, you must continue it until somebody of equal or higher takes over. All right, people dead at the scene. If you see any signs that a person is alive, you should begin providing care. You cannot assume a person is dead unless one of these conditions exist. Decapitation, rigor mortis, which means they're very stiff, they can't be bent, their airway cannot be open. If there's tissue decompensation, and obviously they have been, dead for quite a while. And then dependent lividity. Dependent lividity is a discoloration or bruising either on the back surface or the front surface, whatever surface that they're laying on. That's where the blood has pooled into the tissues, and it is absolutely, you can tell what that looks like. So those are the circumstances that you can pretty much so assure that they're dead. Right. If any of the signs of death are present, consider the patient to be dead. So if you have any of those signs, then we're going to consider them to be gone. It is important that you know your protocol that your department uses in dealing with patients who are dead at the scene. You make sure you need to know that very familiar, so what it is that your department prescribes for that, and how to describe it and how to pronounce people that are dead, not work with them. Right, negligent. Negligence occurs when the patient sustains further injury or harm because the care administered did not meet standards. In order for negligence to be proven, these four conditions must be present. First one, you have to have had a duty to act. You have to be on duty, employed, being paid on duty. Then there has to be a breach of that duty. There has to be resulting injuries because of that breach, and then a cause proximate to whatever your standard of care that you were supposed to deliver. Now, let me make one thing clear on duty to act. You don't necessarily have to be getting paid in dollars. You could be volunteering, but you have committed to volunteer to be on that ambulance or on that fire rescue truck to provide care. You are still on a clock. It's a volunteer clock. So really the duty to act applies at any time that you are on a rescue component, a EMS component, responding in your own car as a designated first responder for some agency. That provides you as a duty to act. Otherwise, you're covered under the Good Samaritan laws. So anyhow, negligence itself, these conditions must be present for this to be proven. Confidentiality. Most patient information is confidential to include the patient's histories, any assessment findings, any treatment that you provide, and your communications with the patient. Information should be shared only with other medical personnel who are directly, and I must make a point of that, directly involved in the patient's care. In certain situations, you may release confidential information to designated individuals. This is all covered under the Health Insurance Portability and Accountability Act of 1996. HIPAA, that is a big word. It's very important to understand that basically it strengthens the laws to protect the privacy of healthcare information and safeguards the patient's confidentiality. Really important to understand that. If you violate these by sharing those information, you can get in significant trouble and or fined and or lose your EMR status. Good Samaritan laws, we talked about this a little bit. It protects citizens from liabilities for errors or omissions in giving good faith emergency care. It varies considerably from state to state. The definition thereof may no longer be needed or provide little to no legal protection as for an EMS provider. But bottom line is that if you're not on duty, you're covered under Good Samaritan laws. If you're not volunteering for an agency or if you're not being paid by an agency, you are covered under Good Samaritan. Now, you still have to operate within your standard of care. You can't start doing brain surgery on people on the side of the road and be covered under the Good Samaritan law. So that's a no-no. Regulations. Become familiar with all your federal and state and local agency regulations that affect your job. Make sure that certification or registration that may be required for you to work as an EMR in a certain state, that may be a requirement, and that you're responsible for keeping your certifications or registrations current. Reportable events. All right, so these are events that must be reported to the appropriate agencies. They're specifically crimes that could include a knife wound, a gunshot wound, motor vehicle collisions, suspected child or elder abuse, domestic violence, dog bites, also rape. You need to learn which crimes are reportable in your area and know your agency's procedures for reporting these crimes. Failure to notify proper authorities of reportable events may result in sanctions against you and or your agency. Crime scene operations. So many times we as emergency responders end up in situations that are crime scenes. So there's several considerations that you got to keep in mind. Number one is protect yourself. Absolutely. If you determine that a crime scene is unsafe, wait in a safe location until law enforcement personnel tell you that it's okay, that it's safe for you to come in. Your first priority is yourself, and then after the crime scene has been secured, your priority is then to the patient. Some other considerations when you're assessing the scene: document anything that seems unusual. Write it down. If you smell something weird, if you see something weird, make sure that you document it. Move the patient only if necessary. Touch only what you need to touch to gain access to the patient. And preserve crime scene for investigation. Don't be messing with things that don't belong to the patient or aren't a part of the patient care. Don't cut through knife or bullet holes in the patient's clothing, because they need to know, they need to see that and document that as part of their investigation. Be careful where you place equipment. You don't want to put it in blood. You don't want to put it on something that could be a footprint, those kind of things. Keep non-essential people away. Work with appropriate law enforcement authorities on the scene, and then write a short or brief synopsis of what that incident is and exactly what you found when you got there. All right, documentation. Documentation is the initial account describing the patient's condition and the care that you administered. It is a legal document, okay? It is a legal record of what your treatment is. It provides for the basis for evaluating quality of your care, all right? And did it work, or was there things that we should change? It is a part of the quality improvement process. It should be very clear, concise, and accurate, very readable. A lot of care nowadays, or a lot of documentation nowadays, is electronic. I'm not so sure how many EMRs are using electronic versions, but all EMTs and paramedics are using electronic version documentation. Documentation should include condition of the patient when found, patient description of the injury or illness, patient's initial and repeated vital signs, the treatment that you gave your patient, and then agency and personnel who took over the treatment, including the names, at least a first name or a badge name. Don't need full, you don't need to put full names, but there needs to be some kind of record of the name and their position, whether they're a paramedic or an EMT that took over. And any reportable conditions, remember, those are the ones that you have to report, like dog bites and domestic abuse, those kind of things. Any reportable conditions present. Documentation should include also any infectious disease exposure. If for some reason you were exposed to blood or to bodily tissues, those kind of things, you need to make sure that it's in there. And then anything unusual regarding the situation. All right, so as a summary, as an emergency medical responder, you have a duty to act, and when you're dispatched to a medical call as a part of your official duties. You need to understand the differences between express consent, implied consent, consent for minors, and consent of patients with mental illness, and the right to refuse care. You need to understand all those parameters. Advanced directives, they give the patient the right to have care withheld. You should understand the concepts of abandonment, negligence, and confidentialities, as well as the purposes and use of the Good Samaritan laws. You also need to understand certain events that deal with contagious disease, abuse, or illegal acts must be reported to proper authorities. In crime scene operations, they're very complex. You need to understand how not to disturb crime scene evidence and those kind of things, and how to be safe within those kind of environments. Your job is not complete until the paperwork is done. I've heard that over and over and over again in my life, so you need to understand that. And then, of course, understanding and following these concepts will help you to be a good emergency medical responder. All right, so as a review, The requirement of this program on every single case, on every PowerPoint, there are 21 lectures in this particular series. We have at the end of each one of these lectures, you have a review. So read each review question carefully. Then pause the video as necessary to read the questions. It's okay, you can pause it. Then I want you to open your email and type in the following information: your name, the chapter number that you're responding to, the question number that you're responding to, and the answer of that question, A, B, C, or D. And then you must give me a short rationalization for the question. You know, why is that answer correct? What is the information that you've learned that supports that answer? And then finally, you need to send it to or email it to us at student@emets.net. It's right up here for you. Here you go, student@emets.net. So let's take the first question. All right, folks, this is your review. Again, emergency medical responders. This is number one. Emergency medical responders have a legal duty to act, A, only when they are being compensated by a certified agency. B, if they witness an emergency scene while not on duty. C, even when outside of their response jurisdiction. D, if they are employed by an agency as an emergency medical responder. Number two, patients are legally able to make decisions regarding their care if they, A, are of legal age according to state law, B, have injuries that are life-threatening, C, refuse transport to the hospital prior to becoming unresponsive, D, have bystanders who can verify their competency. Number three, EMRs have the ethical responsibility to A, provide care only when a paramedic is present, B, discuss details of each case with their coworkers and families, C, transport all patients to the closest hospital, D, conform to acceptable professional standards of conduct. Okay, folks, that's the end of this lecture. We want to thank you for your participation in the program overall. Again, if you have any questions for your instructor, please email them to student@emets.net, and we'll see you next time. Have a good one.